The LegalFuel Speaker Series, Better Lawyer, Better You. LegalFuel is the practice resource center of the Florida Bar and a benefit to Florida Bar members. This ongoing speaker series will feature seasoned leaders from Florida's legal community who represent a wide spectrum of legal expertise and practice. With a focus on the fundamentals of today's legal practice, topics include finance, technology, human resources, marketing, client development, and day-to-day operations of your law firm. The LegalFuel Speaker Series is brought to you by Florida Lawyers Mutual Insurance Company. Florida Lawyers Mutual, defending the reputations of Florida attorneys since 1989. Go to flmic.com to learn more about the company created by lawyers for lawyers. We are now proud to present you the following.
Hi, I'm Brian Tannebaum, General Counsel to Bass Dameron in Miami, and I'm here to talk about 10 ways to avoid bar discipline. Now, if you'll notice, the title is not 10 ways to avoid bar complaints, because you can never avoid somebody filing a bar complaint, but what I'm here to advise you is 10 different ways to try to avoid actually being disciplined by the Florida Bar. My practice is representing lawyers who face bar discipline, and so I'm here to tell you about 10 different ways that I think may help you in your practice to avoid getting some kind of discipline from the bar. So let's talk about the first way. This is actually the number one reason people get bar complaints. It's because of their failure to communicate with their clients. But I also add in here that you should explain things to their clients. A lot of times when clients come in, it's a new client, you're excited about getting retained, getting paid, signing the agreement, but you fail to explain certain aspects of the representation that are important. Let me talk about that first. When you're first sitting with the client at the initial consultation, you need to understand that for the most part, your clients have never been through a legal process before, whether it's a traffic ticket, personal injury case, divorce, bankruptcy, or anything else. This may be the first time they've ever met with a lawyer. So the first thing you should discuss with them is obviously the attorney-client privilege. But then you should go on to discuss things that they may also not know, such as what happens when you go to court. How does the payment schedule work with a lawyer, and what happens when you call a lawyer's office and you need to speak to them? The best thing to explain to your clients is what your schedule is, so that when they're calling to speak to you, they're not upset that you're not there. So for example, I may tell clients, normally I'm in court in the mornings, so the best time to reach me is in the afternoons. That way at 9:01 in the morning, they're not calling concerned that I'm not there. They're calling at 12:30, 1 o'clock, and being told that I'll be back in the office at about 2 o'clock. Rule 4-1.4 talks about communication, and it talks about reasonable communication with clients. So you don't need to call them every day. They may call you every day, but you need to keep them reasonably informed about the representation. And you also need to understand what I said in the beginning, and that is that clients are anxious people. They're concerned about every aspect of their case. So things that you may think are not a big deal, they think are a big deal. So I have a practice that before I go to court, I call my client and explain what may happen. And if they don't have to be in court for their proceeding, then I'll call them afterwards and explain to them exactly what went on. And then I'll memorialize that in some sort of email, or if they want to communicate by text or some other form of communication, maybe just a memo to the file, I make sure I have a memorialization of what happened. You need to also communicate with clients at times, in my opinion, when they're not expecting it. For example, one of the things that I do is I communicate with clients on the weekends because they're not expecting a lawyer to call them on the weekends, and it's also a quieter time. You're not distracted by the phone calls, the people walking down the hall, the people knocking on your door. So you have some time on a Saturday or Sunday to make a list of 3 or 4 clients that you haven't spoken to in a few weeks and just update them on what's going on. Sometimes clients have questions about things that they may not call you about, and if you call them and you reach out to them, you can keep track of that, and you can also keep them informed and keep them from being anxious. That way, if you ever get a complaint that you failed to communicate, you'll have detailed writings regarding when you've communicated with them. And that's important because when a client complains, you need to have some level of evidence, whether it's emails or text or memos or just notes saying, no, I actually did this, and here, Florida Bar, here's when I spoke to the client. So the two most important things regarding communication are not just the actual communication and keeping track of how often you communicate with your clients and making sure you communicate with them, but also explaining to them terms that you and I as lawyers take for granted as just being very common terms. Number two, have a witness. Now, this doesn't mean have a person with you at all times. This means have retainer agreements, have phone records, have memorandum, email, text. Always have something that corroborates your communication, your representation of the client. A client may say that you never sent them a document. If you have a memo, an email, I'm sending you this document, or a text, I put this in the mail today, that's going to help you if you ever get a complaint regarding the fact that you may not have done something for the client. Phone records are also important. A typical complaint from a client may be that he never returned any of my phone calls. If you have those phone records, and they're very simple, you don't have to have a form, you can just write it down in the file that on January 5th you called the client at 3 o'clock and left a message, or that you spoke to the client, if you're keeping hourly time, that you spoke to the client for 20 minutes and it was on this date. And that way, if the bar ever says, this client says you never return their phone calls, you say, well, here's my piece of paper showing exactly how many phone calls I kept. Obviously, some law firms have better technology that way and all phone calls are recorded. But if you're a small solo practitioner and you don't have those kinds of programs, you can just write it down on a piece of paper, scan it into the file, or just keep it on a legal pad. I also believe in retainer agreements. Understand that in Florida, the rules regulating the Florida bar only require retainer agreements in contingency fee cases and cases in which you're going to have specific terms that need to be memorialized, such as that the fee is non-refundable. But my advice is always have a retainer agreement. And what I tell people is put it on a cocktail napkin. People will often tell me, well, I've known this client for a long time. This client is an old friend of mine. I've represented the client on other matters. I didn't think I needed to have something in writing, and now I have a problem because the client's complaining about the fee or complaining about the scope of representation. Always have things in writing explaining what you're going to be doing for the client, how much you're going to be charging, and more importantly, what you're not going to be doing for the client. And let me just give you an example. If you're representing a client in, let's say, a misdemeanor criminal case, you need to put exactly what you're going to do, because what could happen in that case? Well, you could go to trial on that case, the client could be convicted, and there could be an appeal. Well, are you handling that appeal? Are you handling a retrial if a motion for new trial is granted? You need to have in the retainer agreement that this fee covers that aspect of the representation, or that it does not, because frequently a client will say, I thought it was included. And when the client says that and you don't have anything in writing, the bar is going to have a decision to make whether it was actually included. The bar likes to look from the client's perspective as to what they thought was going to happen, and that's why it's very important for lawyers to always have a witness. And what I mean by that again is always have things in writing. Number 3. This is something lawyers don't like to hear. Turn down clients. One of the things I've heard in my practice that I always remember is the best case is the case you don't take. The rules talk about diligence and that you have to act with reasonable diligence. And these cases come up when a lawyer gets a complaint about not filing things, not doing work that's supposed to be done, and the lawyer will say to me, I'm really busy. I have too many cases. And I tell them candidly, the bar doesn't care. Every client deserves the same amount of diligence and zealous advocacy, regardless of how many cases you have, how big your practice is, or what else you're doing. It really doesn't matter that you can't attend to this client because you're doing something else. Now, you can explain to that client why you're not working on their case because something else is going on, and maybe that client will understand that there's going to be some time gap. But if that client doesn't understand and a long time has passed, you also risk doing things like blowing a statute of limitations or missing filing deadlines. So diligence is something that's very important to the bar, and that's why I tell clients, my clients who are lawyers, consider turning down a case because you're not going to be able to handle it, because your office is in Tampa and this is a case in Jacksonville. And although it seems like it's a good case and maybe a good fee, you're going to be called to Jacksonville to handle different hearings, and you're going to have to find coverage, and you're not going to be able to attend, and the client's going to start getting frustrated. So maybe consider turning down a case because you're too busy, because you have too many cases, and because you realize you're not going to be able to be as attentive to that case as you would like to be. My next piece of advice is probably one of the most important pieces of advice I can give you. Have a CPA, bookkeeper, and ethics counsel. Now, for a lot of big firms, this isn't an issue because they have an accounting department and they have general counsel working for them full-time. For example, I'm a general counsel for a law firm full-time. But when I first went out into private practice after working for the government, the first meeting I had was with the CPA. And he didn't charge me for the meeting. We sat down for about an hour and he explained to me how the IRS looks at law firms. And I sat there with a piece of paper and a pen and I wrote down all of this advice, and I've kept it with me forever. I have a CPA that does my taxes. I have a bookkeeper that handles my trust account, and I have ethics counsel. Now, for some of you small sole practitioner lawyers, you're sitting there saying, well, I can't afford all these things. You can't afford not to have them, and there's economical ways to have all of these people work for you. Let me start from the end. When I say ethics counsel, I don't mean having somebody on retainer, which would be nice. I'm talking about having someone that you trust, who understands how the bar operates, that you can go to from time to time and ask questions. You're not always going to have an issue with the bar, and hopefully you'll never have an issue with the bar, but you're always going to have ethics issues, and you're always going to need somebody who isn't involved in your practice to go to and explain certain scenarios so that you can get advice. Don't try to do this on your own because you're likely to make the wrong decision and then you're going to have to deal with the Florida bar. So when I say have ethics counsel, I mean have somebody that you can go to and you can ask ethics advice confidentially. Obviously, another lawyer who's a member of the Florida bar. A bookkeeper is different from a CPA. You're going to spend more time with the bookkeeper. You may have a bookkeeper once a week, maybe every 2 weeks. Maybe your practice is small enough that you only need a bookkeeper to come in at the end of the month and reconcile bank accounts and your trust account. And as far as your CPA, they're going to handle your 1040 tax returns, your 1099s, your W-2s, and other tax forms that you need to use. But let me give you a piece of advice about specifically the CPA. I sit down with my CPA sometimes twice a year just to have a conversation about how much money I think I'm going to make this year, what the differences are in my practice this year, did I get any different types of income that I may need to report, or are there other issues that I don't know about how the IRS has changed their laws that may affect my practice. We're not going over specific issues, we're just generally talking about my practice, the laws regarding the IRS, and getting a handle on what's about to come. The worst time to talk to your CPA is on April 14th, the day before your tax forms are due. And I will tell you that the bar and the Supreme Court are looking more stringently on lawyers failing to file tax returns and failing to pay taxes. So these three elements of your practice, a CPA, a bookkeeper, and ethics counsel, are essential to your practice, and they're CPAs at all price ranges and bookkeepers, and many times you can just have ethics counsel who's a friend, who understands the rules of ethics, who's able to give you advice if you can't afford to put someone on retainer. Consider the length of your career. What we call the catch-all rule, 4-8.4, talks about dishonesty, fraud, making misrepresentations. And you'll see this rule cited in almost every bar complaint. It's important when you're making decisions regarding ethics that you consider the length of your career. And you may say, well, what do you mean by that? And I will tell you. When I was a younger lawyer, I had a very contentious case and I was having issues with the judge, and I was thinking about filing certain things, and a lawyer much older and wiser than me said to me the following: what is it that you want to happen here? And of course I said, well, what do you mean, what do I want to happen here? I want to win the case. And he said, no, think about it from the long term. You're going to see this judge again, you're going to see this other lawyer again, you're going to have these issues in your career. What is it that you want to happen here? And so I've turned this advice around to clients, lawyers that I advise, and I ask them these questions. Because oftentimes what I will do is I will tell a lawyer, yes, what you're asking me is ethical. You are not going to be disciplined for what you do, based on your decision. But I'm not sure it's the right thing to do. I'm not sure it's the right thing to do business-wise, and I'm not sure it's the right thing to do long-term. You have to zealously advocate for your client, and you have to abide by the rules of ethics. But a lot of times you have to make decisions that go beyond that affect other aspects of your career. You never sell out your client, you never do what's wrong for your client, but you also need to understand that you're a member of the bar and you need to keep your license. So you don't want to lose your reputation as a lawyer for a decision that you really don't need to make. So as I say on this part of the talk, consider the length of your career and consider that what you do now may be with you for the rest of your career. Lawyers talk, judges talk, and you don't want to be one of those lawyers that's looked upon as untrustworthy or someone that a judge just doesn't want in their courtroom. My next piece of advice is hit save instead of send. Many of you know that the oath of attorney has been amended and that civility is now a part of that. There is a major concern about lawyers being uncivil to each other and also being uncivil to judges and uncivil to clients. The issue for me is really the advent of technology, because technology allows us to speak a lot quicker. It used to be that we would write a letter to a lawyer and wait 2 weeks to get a response. Now we send an email and we want a response within minutes, or within an hour, or within the same day. And often what happens is emails become emotional. People always ask, what does the E on email stand for? And obviously it stands for electronic mail, but there's also two other ways to look at that: emotional mail or evidence mail. You need to understand that every email you send and every email you receive is there forever. And oftentimes a bar complaint that I read on behalf of a client is nothing more than an attachment of emails between two lawyers or between a lawyer and a client. So I say hit save instead of send. You're going to get emails that are going to upset you. You're going to get communications that are going to upset you. It's not the news you expected, the lawyer's being a jerk, you're not having success in what you're trying to do, and it's elevating. And when it elevates on both sides. So I always say, when you write that response to that jerk of a lawyer, or that offer that you got that you believe is completely unreasonable, or that email that you received that you believe may be unethical, hit save instead of send. 24 hours is a long time, and it's a time for everybody to calm down. And I guarantee you, because I've done it and I've seen it, that when you write an email and you hit save and you look at it the next day, you're going to change it. Because when you have time to reflect, 24 hours, maybe just 12 hours, you're going to change your attitude and you're going to think about the length of your career. And you're also going to be thinking about who's going to see this email. Because if the bar sees it and they start asking questions about your civility, you need to understand that you could be facing public discipline just based on your behavior, having nothing to do with the practice of law. So always consider taking a moment, pausing, and thinking about not only what you're going to say, but what you're going to send. Be competent about your incompetence. You are required under the rules to provide competent representation. And what that means is you have to know what you're doing. You don't have to know everything, and the rules regulating the Florida bar allow you to take on cases that you've never taken on before. But understand again that you have a reputation and you have a license. And if you're going to take on a matter for which you've never handled before, let me give you some advice. Obviously, there's lawyers out there who have handled those types of cases. When I was a young lawyer and I hadn't handled any ethics matters, I started calling lawyers that had handled significant ethics matters, and they were very receptive to me. And they were happy to give advice, and we developed great relationships. It's important to know that there's over 100,000 lawyers in the Florida bar, and there's probably nothing that hasn't been done before by one of these lawyers. You just need to find the one that is willing to help you. Don't take on a case that you know nothing about, where there's certain types of filing deadlines and rules and requirements that you don't know about. Because what's going to happen is you're going to miss deadlines. You're going to not understand that there's certain statutes that specifically apply to the type of case you're taking. And the way you're going to find out about that is when a judge issues an order saying, how come you didn't file this? Or how come you didn't cite this statute? Or how come this affidavit wasn't filed? And it's only because you had no idea and you didn't ask anybody. And when you provide incompetent representation, it's going to affect you based on what type of discipline you may receive and also the reputation that you may get. Remember, we have the internet. And if you get public discipline these days, it's on the internet. You don't want people to know that you took on a case for which you had no knowledge of how to handle it. So when the bar says you must provide competent representation, you're allowed to take on cases that you've never handled before. But do yourself a favor. Don't be a maverick. Don't just read the statutes and the case law. Pick up the phone, send an email to a lawyer who's handled these matters before, and spend some time, because I guarantee you're going to learn information about things that aren't in writing, and it's going to help you save yourself from future bar discipline. Understand the bar's role. The Florida bar is here to protect the public. It's also here to assist lawyers, but those roles run in the same circles. The bar is not a union for lawyers, and the bar will discipline you for violating the rules, and they will do everything they can to protect the public from who they believe are lawyers who shouldn't be licensed to practice law. The bar has a great many resources, and they're constantly updating their website. You can now search fully all ethics opinions. And ethics opinions are important because you have the rules and you have the comments to the rules, but ethics opinions are analysis of the different rules. And you may find your scenario that you're having a problem with in an ethics rule. You can just go on the website and hit ethics, and it will come up with the rules and the ethics opinions, and you can type in your keyword search, and it will come up with ethics opinions that the bar has issued for scenarios that you're going through right now. The rules regulating the Florida bar are also on the website, and also the commentary, and I urge lawyers all the time to read the commentary to the rules, because there are analysis in there and specific instances of where the rule may apply. What the bar is doing in the commentary is explaining how the rule works, which is what you need to know, because you can read a rule and say, okay, I understand what it says, but how does it actually apply in practice? So always read the commentary to every rule to get more sense of what the bar's interpretation of the rule is. The bar is also there to give you advice, and I'll get to that in a minute, but if you ever need advice, you can call the bar and they will advise you prior to you doing anything unethical how to resolve your situation. That's the Florida Bar Ethics Hotline. And this is a very important phone number. You should put it in your phone, put it in your computer, keep it next to your desk. You can call the Florida Bar Ethics Hotline anytime to get advice on ethics issues. They will give you a number so that you can have a record of the call that you made, and it may help you in the future if in fact you do get a complaint. You can put in the response to the complaint, I called the Florida Bar Ethics Hotline, this is the advice that they gave me, I took their advice, and now I'm receiving a complaint for this conduct. It may not absolve you if you've actually done something unethical, but it could be very helpful in stopping you from doing something that will get you in hot water with the Florida bar. Often people call me and ask for ethics advice, and I will give them the ethics advice, but I say, listen, do yourself a favor. Just for my own sense, call the Florida Bar Ethics Hotline, see if they give you the same advice. So do yourself a favor and keep this number handy. It's one of the best services that the bar offers. My last piece of advice is the most important piece of advice, and that is to know when you have a problem. This is for the health and well-being of all lawyers, because if you're not healthy and you're not well, none of this will matter. Florida Lawyers Assistance Incorporated is the greatest resource the bar has for the health and welfare of lawyers. And this covers drugs, alcohol, gambling, any problem that you may be having. And the most important thing I will tell you is that it is completely confidential. And people will debate this with me that they don't think it is, but I am telling you that it is completely confidential. Oftentimes I will refer clients to Florida Lawyers Assistance, and Florida Lawyers Assistance will not talk to me unless the client gives consent for them to talk to me, even though they know that I represent the lawyer. If you think you have a problem with drugs or alcohol or gambling or anything at all that affects your well-being, please call Florida Lawyers Assistance, sit down with one of their people, and talk to them. Get an evaluation. Because if in fact you do something in your practice that could be subject to discipline and you have an issue, the bar is going to take that into consideration. And the bar is going to try to do everything they can to make sure that you are healthy and you are well. It's not going to absolve you from all types of unethical conduct. But if the bar believes that your conduct had something to do with the fact that you're not well, that you have a drug problem, that you have an alcohol or gambling or other problem, they're going to take that into account. So do yourself a favor. If you think you have a problem, whether you've received a bar complaint or whether you're just starting to think that something's not right, call Florida Lawyers Assistance, talk to one of their people. They're all wonderful people and they're there to help you. So to summarize, you can never prevent somebody from filing a bar complaint, but you can try to help yourself from getting disciplined by the Florida Bar. Communicate with your clients, make sure you explain things to them, make sure you have things in writing. Make sure that the client understands what the representation is all about. Make sure you understand how to be civil to other lawyers and to keep track of everything that you're doing, whether it be in an email or a text or anywhere else in your practice. Just on a legal pad is fine. Make sure that you, as I say, have a witness so that if somebody does come calling, complaining about your ethics, you can explain to the bar that you've actually done the things that you've been accused of. If you have a problem, make sure you contact the bar, whether it's the Florida Bar Ethics Hotline looking for ethics advice, or whether you actually have a physical or mental problem that the Florida Bar should know about so that they can help you prior to seeking bar discipline. And lastly, take a look at the rules again. A lot of us haven't looked at them since we took the Florida Bar. Read them, read the comments, they've been updated, and make sure you understand how to be ethical. Thank you.
LegalFuel connects Florida bar members with strategic tools designed to help you fuel your law practice with increased efficiencies and profitability. Whether you want to launch a new firm, better market your services, or strengthen your internal operations, LegalFuel provides attorneys with the resources you need to run your business smarter and more efficiently. Visit LegalFuel.com today to help manage your practice and fuel your business.